With effect from the 9th of May, Singapore government introduced a new cooling measure. Hello everyone, this is Alex Chua from Home of the Elites and welcome to another episode of Always Ask Alex. And what is today's episode all about? You may already know that with effect from the 9th of May, Singapore government introduced a new cooling measure which imposes a 35% additional buyer stamp duties on residential properties purchased under a living trust. Well, there are many types of trusts which can be confusing for most lay people. So today, I am visiting an old friend, Maurice Lee, who is a lawyer with more than 30 years experience in the legal practice. So do join me and we hear from Maurice.
Hey, Alex.
Hey, hello,
Hey, thanks
bro.
for dropping by, man.
No problem. Thanks for helping us with this sharing session. So, of course, we know that government announced some cooling measures on the 9th of May. And, of course, right on the same day itself, I have a lot of inquiries from friends, from relatives, from some of my clients. They are very much concerned. How would this affect them? So, of course, me being the real estate person and you are the person that is probably the right person to answer all these questions.
Work together lah.
Okay. So maybe just to help our viewers understand, first and foremost, understand there are many different types of trusts. So let's begin with what is a trust?
Okay, Alex, that's a very good question. I think if you want to talk about using a trust to buy a property, it's important to know what's the trust. Let me try to explain to you in layman term. Assuming I have this pen here. Okay, so the law recognizes there are two kinds of ownership, legal ownership and beneficial ownership. Legal ownership means the person who is legally reflected as an owner. Okay, whereas the beneficial ownership is the person who has the benefits of this pen, although that person may not be legally in charge of this pen. So let's say I want to give it to my son, and but I'm very peculiar. I told my son, you can only use this pen to sign on white color paper. All other colors you cannot sign. But I don't really trust him. So what do? I legally transfer this pen to you. So now you're the legal owner of this pen. But you cannot use it for your own benefit. You can only give it to my son when he wants to sign on a white piece of paper. So he has the benefit of using this pen, whereas you're the legal owner of this pen. So I hope you can understand in simple terms what a trust is.
Right, okay. But there are also different types of trust because I know there are some so-called property buyers who bought under their children's name and their children is not even 21 years old. They form a trust.
Yes.
But the recent one they are talking about, a living trust.
Okay. Living trust. That one's easy. There are only two ways you can do a trust. While you're alive or while you're dead. Okay? So if you want a trust that only comes to effect when you're dead, it is by way of writing a will. And that is called a testamentary trust. But as long as you are alive and you write a will, or you create a trust, that is called a living trust. So it's very simple, you know.
Okay. So is it that anyone can set a trust just to buy residential properties?
Yes and no. To set up a trust, first and foremost, you need to have a lot of money. Okay. Mostly the high net worth or the family office, they are the one that consider setting up a trust. Maybe the way to answer is how do I use a trust to structure a purchase of a property? Let's say myself, I not that I'm rich, I want to buy a property for my son who is only 2 years old. So, and the property is $1 million, just for discussion. So I set up a trust, I call it the Love Trust. And I put $1 million, I settle this $1 million into this Love Trust. And I appoint myself to be the trustee. But I name my son as a beneficiary. So I use this $1 million, the trust, use this $1 million to buy the property. Okay? So this is how usually people structure a purchase of a property using a trust. You know, they set up a trust, they put the money into the trust, then the trustee will use the money to buy the assets.
Okay. So for trust is that once your son reaches 21 years old, he has full control of the trust and the property itself?
It depends on how the trust instrument is drafted. Sometimes I may say not 21 years old. Sometimes I say only 40 years old. Sometimes I may put 50 years old. Okay?
Okay.
So there are conditions that you can set to a trust. I mean, there's a saying, with a trust, you can vicariously manage your loved one from your grave. But I don't think we're here to talk about that today, you know?
Okay. And how is living trust different as compared to, because earlier you shared that living trust is more like a after death sort of succession plan for the property to be transferred to someone else?
Okay, let me try to reframe the question. So, let's say I have a living trust, and I use a trust to buy a property, and the beneficiary is my son. Okay, so when I'm no longer around, the trust will continue to hold the assets for the benefit of my son. So in a way, you know, it does serve a purpose. There is a trustee overlooking the assets for the benefit of my son.
Okay. So what happened in the past was there was no ABSD, and property buyers are using this as a vehicle to buy their second property, their third properties, without getting the additional buyer's stamp duties.
Okay, yes, that's true, all right. But I think we have to use the terminology correctly. I think what most buyers did in the past is that it's called effective or efficient tax planning. No, tax planning, tax avoidance is not a crime, okay? But tax evasion is a crime. So I honestly beg everyone, please do not evade tax, all right? But tax avoidance, tax planning, at worst, is a sin, okay? But it's not a crime.
Right.
But you can actually use this to legally avoid paying ABSD. But that was before the 9th of May 2022. Since then, there have been some new measures that has been announced by IRAS, and the new measures is called the ABSD trust. You know, and based on the new measures, when you set up a trust to buy a property for a beneficiary, immediately you need to pay 35% upfront. Whereas in the old days, you only pay the BSD, which is 4%.
Right, okay. So let's use a ballpark figure, for example, a property that is transacted at $1 million. So we know that the buyer's stamp duties, the usual buyer's stamp duty is still payable.
Yeah.
So the additional 35% is based on 35% of $1 million.
Yes.
And we also know that at some point, or maybe under some circumstances, they can actually do a remission.
Okay, yes. Under the ABSD trust, there are conditions to be fulfilled, and if you fulfill the conditions, you can apply to IRAS for remission of the ABSD of 35%. And there are 3 conditions to be met, and you have to be very, very careful. Okay, the first condition is that there must be an identifiable beneficiary. Now, in the past, before the 9th of May, you can set up a trust to buy a property without naming a specific beneficiary in the trust document. It can be a class of beneficiaries, or it can be children to be born. Okay, but these whole things are gone. Now, under the new rules, at the declaration of the trust, you must have an identifiable beneficiary. Okay, the second conditions to be fulfilled is that you must pay the ABSD upfront first. That means come out 35%, then you take it back. And the third condition is that you must apply within 6 months from the date of the instrument. Instruments means the property instrument. Most likely is on the date of the exercise of the option. Okay? Now, let's circle back to the condition 1. The identifier beneficiary is a very important condition. At the declaration of the trust, you must have a name of a beneficiary. Even if your child is 1 year old, the name must be there. There must be documents to prove it. Most likely, if it's a child, it's a birth certificate before the IC is issued. Okay, but there are other conditions to be fulfilled. The trust cannot be revoked. It cannot be varied. And there must not be conditions subsequent to the trust. So basically, you no longer can set conditions. In the past, you can set up a trust and say, my son can only, this property will only be transferred to my son when he is 40 years old, or when he has a PhD. Now, no more. Under the new rules, okay, you cannot set conditions. It cannot be revoked, and you cannot even vary the terms of the trust. So it's like a fixed trust already. You know, there's not much of discretion for the trustee already.
Right.
So 3 conditions, remember that. If you fulfill the 3 conditions, nothing goes wrong, you'll get back your money, 35%.
Right, okay. Wow, Maurice, that's really a lot of information to absorb. So, of course, I'm also very curious. What happens to those trusts that was, before the 9th of May? Will they be affected by the new cooling measures?
I can answer you immediately. No. It is not retrospective. Okay, that means it only applies to trust after, from 9th of May onwards. So, if you have done it in the past, don't worry, sleep in peace. Nothing will happen to you.
Right, okay. So based on what I've learned today, does it still make sense to buy a residential property under a trust?
Well, if you are a high net worth individual or you have a family office and you want to buy assets for your young children, it's not a bad thing. The ABSD trust rules is not designed to kill it off. To a certain extent, is an equalizer. Because previously you can name, you can have unnamed beneficiaries, and now you have named beneficiaries. But if you fulfill the 3 conditions, you still can apply for remission and you can get back the 35%. So at the end of the day, you only end up paying the buyer's stamp duty. So there are advantages. I think the only issue that may come across a hindrance is the cash flow. But then again, if you are a multi-billionaire, maybe $1-2 million in ABSD to you is just a rounding error. You wouldn't even blink an eye. So at that kind of level, I don't think it will impact the market.
Right, okay. But would there be cases whereby the beneficiary choose to renounce the
Of course,
trust?
Definitely. I'll give you an example. Let's say your father named you as a named beneficiary. So, up immediately, under the ABSD rule, 1 count already, right?
Oh, okay.
True or not? Then you want to buy another property. Immediately, you have to pay ABSD already, right? Second property. You may come to me as a trustee and say, hey, I don't want. I want to renounce it. You can, But bear in mind, there are rules now regarding renunciation. If you renounce it within the SSD period, seller stamp duties period, you may end up paying SSD. All right? But when the asset revert back to me, the settler, then I may attract ABSD. So either way, you can't run away. All right? If there's tax to be paid, render to Caesar what is Caesar, and render to God what is God.
Right, okay. Yeah. So in fact, there are many considerations to think about before even setting up a trust or even deciding to appoint a beneficiary. But what about the whole process of creating a trust? Is it complex? Is it quite straightforward? And also, what would be the estimated cost?
Wow, that's a loaded question. Let me try to unpack it. I think there are 2 steps. You don't set up a trust without having a property. First and foremost, go and talk to your real estate professional. Get them to help you to hunt for your dream property. And once you have that assets in mind, come to see a lawyer, and we'll sit down and we'll structure the trust for you. And we have to draft the trust instrument very carefully to comply with the conditions stated in the ABSD trust rules. Okay? And then once the trust is set up, then you can proceed with the purchase of the assets of the property. Whole process, conveyancing, usually about 3 months, Throwing the trust, maybe about 4 months. Cost-wise, for setting up a trust, it depends on the complexity. It can range anything from $5,000 to $20,000-$30,000. It all depends on the complexity, But if a trust is set up specifically just for the purpose of buying an asset, I don't think it can go way up to north.
Right. Okay. But assuming I'm a very kiasi Singaporean, do people do it the other way around, whereby they set up a trust first even before identifying or before buying a property, instead of buying a property and setting up the trust?
There's nothing wrong with it. You can also. You can just set up a trust first. It's called standby trust. And then when the dream property comes along, then you activate it.
Right.
But the only issue, I think the issue is Yeah, we need to name the beneficiary. So the beneficiary must be named at the point of purchase of the assets.
Okay, so when I set up the trust, I may not have any beneficiary
Beneficiary in
yet,
mind.
but at the point of time of purchasing the properties,
You must have a named beneficiary.
I see what you mean. Okay,
That's the whole purpose of the ABSD trust rules.
right. Okay, so Maurice, one more question. So if I am an existing property owner and my dad wants to set up a trust and name me as a beneficiary, how would that affect me?
Well, good news and bad news. The good news is that you're going to have another property under the name. But because you are an existing, you already own one property, and when you are named as the beneficiary in your dad's trust as the beneficial owner of the other property, so when your dad applies for the remission, it will not be the whole 35%. It will be the 35% minus the rate, the ABSD you're supposed to pay for your second property. You know,
okay.
so it's not like because of that, of the trust, you get away with ABSD. No, it doesn't work this way. Okay, but it's still okay. I mean, if that's what your dad wants, you still not owning another asset.
Right. And perhaps I should just ask my dad to give to buy under my name, and I'll just pay the 17% instead of the 35%.
Yeah, I think maybe it's better this way. It's less complicated. But then again, it's your father's money.
Okay, right. Hey Maurice, thanks for all the sharing session, and for all the viewers out there who are watching, I will leave Maurice's contact number at the end of this video. And if you do have any questions to understand more about setting up a trust or understanding more about what is a living trust, you can just feel free to reach out to Maurice, and I'm sure he'll be more than happy to assist you.